This is December 17, 2009, hearing of the Radnor Township Zoning Hearing Board. The first matter we'll hear this evening is appeal number 2820, Mr. James Schneller's appeal of alterations to the sidewalk and plaza in front of 103 North Wayne Avenue, and the erection of a fence in front of the property as well, without a permit nor approval of the department or any other official. This is an appeal of any approval or deemed approval that exists. Existence of a town commons is requested to be found. This matter was continued from the November hearing. You're right. We actually have an administrative matter first. It's a November 20 letter to Mr. Matthew Bauman from F. Harry Speece Jr. regarding Montgomery Del Valle Associates LP, appeal number 2717, 313 Conestoga Road, Wayne, PA. Dear Matt, as your records will indicate, I represented Montgomery Del Valle Associates LP, owners of 313 Conestoga Road, Wayne, and secured zoning relief from the Radnor Township Zoning Hearing Board, enabling them to construct a dwelling and garage on a non-conforming lot that previously housed a home that had been totally destroyed by fire. Adverse economic conditions have prohibited Montgomery Del Valle Associates from proceeding to apply for a building permit to construct the home and garage that was approved by the ZHB. The purpose of this letter is to seek another 6-month extension for the owners to secure a building permit for construction of the dwelling and garage. One of the partners or representatives of Montgomery Del Valle Associates LP will be present at the ZHB meeting scheduled for Thursday, December 17 at the Radnor Township Building. If you have any questions concerning any aspect of the foregoing request, please do not hesitate to contact me. Is there a representative of Montgomery Del Valle? If you'd come up, sir, identify yourself and be sworn.
I do. I'm Jeff Pendergast.
Mr. Pendergast, what's up?
That letter pretty much says it all. It's, we would like to get an extension on the zoning. We're hoping that we can get going with that project, which is a single-family home, this spring.
Okay. Can you tell me when the relief was granted originally?
You know, I don't know exactly. I think this might be our 4th extension.
Okay.
3rd or 4th extension.
And you want 6 months from today, or
Yes.
from whenever? Charlie or Kathy, you have any comments or concerns?
I normally wouldn't go for extensions, but I think considering the economic conditions as they've been the last year or so, that I would vote for it.
Okay. You okay, Charlie?
I agree with Kathy. That's kind of beyond how long we go, but conditions, the economic conditions definitely affect it.
Cora? Okay. The extension's granted. Thank you, Mr. Pendergast.
Thank you very much, Mr. Tall.
Okay. Mr. Schneller, the floor is yours. First, we're going to have some preliminary comments from our solicitor, Mr. Ryan.
Good evening. This appeal is a rather unique appeal that's come before us, and I think we met in executive session for me to share some concerns with the board, and I've been instructed to give a synopsis of those, publicly, and then the board will decide how it wishes to proceed with the hearing. The appellant, Mr. Schneller, has appealed a letter issued by Mr. Bauman, the township zoning officer. He originally filed an appeal with respect to certain alleged interferences of a sidewalk at 103 North Wayne Avenue, and filed an appeal of that, and the township refused to accept it on the grounds that he's not the property owner and that the zoning board does not have the authority to undertake the procedures and relief that were specified in his request. When the township issued the letter returning that, Mr. Schneller appealed that, and that is a determination by the zoning officer, which can come up to the board, but this board still has to address 2 questions. One, does the appellant have standing to challenge the use of property at 103 North Wayne Avenue? I believe, Mr. Schneller, you're at 500 East Lancaster Avenue, and under Pennsylvania law, in order to challenge use of land, you have to own, lease, or occupy land that is sufficiently close to the land on which the use is complained of, in order to have a distinct adverse impact on your own land, and that's what gives you standing to come to a zoning board. And in the absence of that, an appellant doesn't have standing. The second issue is, can the zoning board do what you would like us to do in your appeal? As I've read it, there are a number of items that you're requesting that we investigate whether appropriate ordinances were complied with, whether permits were properly issued. I believe a couple of the items go to whether there's a town common in that part of Wayne that needs to be respected, and whether we should make a determination of whether fines or penalties should be assessed. The zoning board has very limited jurisdiction. We're a creature of the Pennsylvania Municipalities Planning Code, and we may do fully what we are authorized to do, what the board is authorized to do, but it can't do other things. And, for example, zoning boards have no enforcement powers. We have no authority to issue cease and desist orders, to fine people, or anything like that. Zoning boards, basically what the zoning board can do is to appeal a determination of the zoning officer. We can hear a substantive challenge to the validity of an ordinance, and we can we consider and decide special exceptions and variances, but that's what the statute says. And in my read of the law, in fact, there's a case, Grand Central Sanitary Landfill, a 1993 Commonwealth Court case. Zoning boards are authorized to decide variances. In that instance, a zoning board decided a variance and then changed its mind a year later and redecided the variance. And the Commonwealth Court said that you only have the powers that are in the statute. You have the power to decide, but there's nothing in there about the power to change your mind and amend. Therefore, the statute does not give the zoning board the power to do what it purported to do, and the action was void. So in addition to whether the applicant has standing, I have advised the board that it needs to make a determination on whether the board has the authority to undertake the actions, procedures, investigations, or grant the relief that the applicant would like the board to do. I've addressed this directly with the appellant, including by letter dated September 30, that I shared the township's concerns on standing and on whether the zoning board has authority to proceed with what is requested of it, and that I would, suggested that the applicant be prepared to address that if he did, at the outset, if he chose to bring an appeal to the board. My recommendation to the board for the board's consideration is that we start the hearing and address first the two issues that were raised initially by the township. Does the appellant have standing to bring this appeal vis-a-vis 103 North Wayne Avenue? And does the zoning board have authority, assuming the appellant does have standing, does the zoning board have authority to undertake what the appellant would like us to undertake? And my advice to the board, recommendation to the board, is if the board, having considered those two issues, determines either that the appellant doesn't have standing and or that the board doesn't have authority to do what is asked of it, that it should stop at that point and decline the rule against the appeal. And so that is my recommendation to the board on how to proceed this evening for the board's consideration.
Mr. Schneller, with Mr. Ryan's comments in mind, please begin. If you'd be sworn, yes.
I do. James Schneller, Schneller.
Mr. Schneller, there's a couple of preliminary matters. You've submitted a memorandum of law on, I guess it was December 4th. It was received by the Township. I've sent this to the board, and we probably ought to enter that into the record as an exhibit. I think your appeal itself would be A1, and the memo of law would be A2, if that's okay.
Thank you. If I could also submit, would it be appropriate to submit your response letter that you just mentioned?
You're free to do that. And that would be A3?
Absolutely.
Yeah, please. These are extra copies for the board.
Mr. Craig is here as well. Thank you.
Okay. So this is my September 30 letter is A3. And then, Mr. Schneller, I received also from the Township and then from you directly a letter dated December 14 with a letter of objections, including objections to notice. Should this be entered into the record as well?
Yes, please.
Okay. This letter, and I've sent this to the board before, but I've bought extra copies. It's a letter dated December 14, 2009, and we will mark that A4. I understand, by the way, that Mr. Baumann and the Township Solicitor are here tonight to address this appeal.
Okay, Mr. Schneller, if you'd address the standing issue.
Yes,
First.
thank you. I'm Jim Schneller, and I live in St. David's Park, which is in the town of Wayne, and I am a everyday visitor to the exact location that is at issue in this appeal, which is right next to the shoe store and Farnham's Jeweler, next to where the old ice cream candy store was on North Wayne, just off the corner. And I have claimed in my appeal, if I could also ask something procedural, would it be possible to request the board from the outset to vote or otherwise decide the standing issue so that we wouldn't have to proceed to merits needlessly?
You can request what you like. My recommendation to the board is that we address both the standing issues and the standing issue and whether we have the authority issue, whether we have the jurisdiction to do what you would have us do, and that the board vote them at that point. The board, that's up to the board to decide what it'll do, but you may ask for to do it in any order you wish, and that's the board's decision.
Before we would get to merits, we would address both the standing and authority questions. So we would not go to the merits of the appeal.
I welcome Mr. Baumann's being here, and I want to make sure that everyone understands that it is the township, or at least the recommendation of the solicitor, that the matter somewhat center on the letter, which is attached to the appeal from the Department of Community Development, preventing the initial appeal I took, which was as summarized by Mr. Ryan, much more a matter of substance of a sidewalk and encumbrance on the sidewalk and how it came to be there. As far as the standing issue, I actually have a preliminary issue of lack of notice, and it is in the letter A4. At least that's how I would claim I raised it. The notice posted at the site is on a telephone pole facing the street. When I observed it on the second evening of posting, which would have been Friday, it was rain-soaked and running. The ink was running, or at least it had gotten to the point where no one would give it a second glance. And the only people really capable of reading this, I also state in the letter that it's gray, and I say it's gray rather than black on white because it's printed at a very low intensity, or maybe the weather had done that already. the only people that could read this notice are people who were turning right off of Lancaster Pike and going towards the train station, and we all know that no one stops there ever. I think for someone to see this notice, they perhaps would be walking a dog, and likewise, there is no proclivity to people walking dogs at that corner. And finally, someone standing at the traffic light going across Lancaster towards the post office would have to have excellent vision to read it. And I'm convinced, and I think under all possible scenarios, that notice hasn't occurred.
Well, it's on the website of the town, right?
Right.
And notice was given in the paper, isn't that right?
And Mr. Schneller noticed it. So he's the only one here complaining about it.
Right.
He noticed it. He knows it's there. He knows what it says, right, Mr. Schneller?
Of course I noticed it, but
Okay.
I'm a party, and I am scrutinizing to make sure notice. I don't think that as was emphasized at the Board of Commissioners meeting this week, although we'd like to think that 60% of the people are paying attention in some way, or even 40% of the citizens are paying attention, it's more like 10 or lower.
Well, Mr. Schneller, you want to continue this hearing because of the failure of notice? Or do you want to
Yes.
go for it? You want to continue the hearing?
Yes. Simply for the propriety of the action, and because of the fact that I represent myself, I have this aura of possibly being a little bit too busybody and filing too many papers. If we could keep that separate from this appeal, it would be.
Well, they're part and parcel of the same thing. Either we have notice and this is, and we will go forward, or the notice is defective and we don't. So,
Well, let me add, if I could, another detail. To my knowledge, notice in the publication occurred last Thursday, which was the 10th approximately. And
we have that information. Matt, do you have that information on?
It should be in the file. John, do you have the?
Okay, I have it here. Yep. Dates of advertisement were December 2 and December 9. Notice was provided to Township staff on November 27th, and the property was posted on November 30th. So, to be perfectly frank, Mr. Schneller, from my perspective, notice was appropriate. Does anyone on the board have any concerns about the notice in this matter?
For this meeting, it was noticed in December, but I believe he was originally scheduled for November.
Yep.
Is that correct?
That's correct.
Was notice posted in November?
Yes, it was.
And how many times that?
No, I'm sorry. I stand corrected. It was Mr. Schneller sent in a continuance.
Yeah, the matter was posted in, it was originally posted in November.
But did he send his
Yeah,
request
well,
for continuance in before?
He
My
did.
apologies.
He did.
Posted?
My apologies.
Okay.
It was also advertised November 4 and November 11, and posted October 29th.
Oh, welcome.
And then I believe we stated at the November meeting that it was continued, and
Yes.
that would have been televised.
Yes. I think we should move forward, Mr. Schneller. If you address the standing question.
do I have any say in the matter? I mean, obviously not, but I'd like to ask once again that it be continued.
It would be my recommendation to the board that we deny your request for continuance. Does anybody have a contrary view?
Why would we continue?
What is the basis for requesting that?
So the public can have proper notice.
They've been notified twice, 2 months.
Since October.
Several times, in November and December.
However, the actual physical posting is a crucial part of this.
It was physically posted in October and November. So let's move forward, and if you elect to appeal that determination, you can appeal from that determination as well.
Plus, it was also televised at our November meeting that it was going to be this month.
Yet the public passing the location, who is the public most acutely aware.
Mr. Schneller, we're going to move on from the notice question and move on to standing, if you don't mind.
Yes, thank you. As to standing, the board, and please stop me whenever necessary, the board's aware that my standing issue is before the appellate courts, and I won't go into that except that I wish to urge you not to apply any conflict of any decision you make with what's been decided. If I could put it in a nutshell, the Common Pleas Court decided in what appeared to be a very comprehensive manner.
Mr. Schneller, just
I'm going to object. Maybe it would help if I asked Mr. Schneller some questions about his standing, because I think that issue is what is before this board. Your standing, Mr. Schneller, in the 3 other cases that you've appealed that have been up through the Commonwealth Court and the Pennsylvania Supreme Court is not an issue here. The only issue here, as I understand it, is your standing in this appeal. So how far do you live, Mr. Schneller, from this property? Do you
Can I
know?
say that I just wanted to raise the res judicata estoppel matter because they must,
No, he's counsel.
they must think there is some relevance, right? Or can you instruct them?
I think
to-
the board.
One second. Mr. Rice, would you mind identifying yourself for the audience and for the
I'm
record?
sorry. John Rice, I've been authorized by the Board of Commissioners, and I would like to enter my appearance officially. I'm here on behalf of the township opposing Mr. Schneller's application. We do not believe he has standing.
I wasn't aware of this. I thought-
We believe that the issues he's attempting to raise in front of this board are not issues, they're questions. There's nothing in the MPC that gives this board jurisdiction to answer those questions. And the third issue is that building permit for this property was originally issued, and we can provide this to the board, in 2008, for this property. It's when the building permit was issued. You get 30 days under the MPC to appeal permits. And if you don't appeal permits, you're out of court. The second issue regarding timeliness is Mr. Schneller's Exhibit A3 is a letter from Mr. Ryan dated September 30th, 2009, advising Mr. Schneller that he needs to appeal the September 9th letter that Matt Baumann had issued to Mr. Baumann within 30 days. He didn't appeal that within 30 days either. He appealed that. We have a receipt of the permit fee with a date of October 16th. So he's blown all the appeal periods regarding any of the permits on this property. He's missed the 30 days from Mr. Baumann's September 8th, 2009 letter, which is the subject of this appeal. I'll give you the state statute essentially says, I believe it's section 914.1 of the municipality's planning code, time limitations. No person shall be allowed to file any proceeding with the board later than 30 days after a permit has been issued or after you've known a permit has been issued. I'm paraphrasing now. So you have 3 reasons. Any of those 3 reasons are sufficient not to go forward. If the board would like, we can mark the initial permit from August of 2008. We have the receipt, or Mr. Baumann can testify as to when this appeal was received, which was October 16th of 2009. And we have a map showing where Mr. Schneller actually lives in relation to this property. So
Why don't we have all those items marked for the record? And let's show them to Mr. Schneller if he hasn't already seen them.
Mr. Schneller, this is a map of, it shows 103 North Wayne at this location, and 500 East Lancaster Avenue, which is approximately where you live in this apartment complex.
Mr. Rice, could you slide it just a bit so that we get it all on the screen?
Okay.
Thank you.
This is the apartment complex you live in.
Yes, I live in this building here.
111D, I think, is on all your applications. right?
Yes.
That's your apartment number?
Yes.
Okay. So you live here. This is the property that's the subject of your appeal. And it's about 0.75 miles. disagree with the location of those two properties? Or do they look
I do not.
do they look accurate to you?
The map looks to scale, yes.
It's actually an overhead photo, right?
It is, from DVRPC's aerial, 2005.
As to the distance of 3/4 mile, I can't confirm or deny that.
Okay.
Mr. Chairman, maybe it would, what I would like to do is if I could have that map marked as T1,
Okay.
Township 1, and maybe it would, just to, so it's clear what we're doing here, I can call Mr. Ballman to address the timeliness issue, the standing issue, this map, the preliminary issues, assuming you're not going to get to the substance of the question. So if I could have Mr. Ballman sworn in, I'd like
Well,
to.
let's do that, but I'd like to actually, let's give Mr. Schneller just a couple minutes to see if he can get his legs under him on the standing question.
Could I, before testimony by Mr. Baumann, which might be better first, I have a very obvious response to the matter of timeliness. I filed a brief within 10 days of today, and I've had no notice of this timeliness issue. I honestly haven't.
Okay.
And I am a timely, rather diligent person, and I happen to know that most of the timeliness is leveled against me are quite arguable. I'd like to present.
Okay, I'd like to add something. I received, going through my file, a letter from Mr. Schneller on the 22nd that was attaching appeal. I think it's the same appeal that ultimately was filed. And my copy, unless I'm missing something, of the actual appeal before us that I've got doesn't seem to be time-stamped. But for what it's worth, he wrote me on the 22nd and
22nd of what
of
month?
September. And in it is a request that that the board consider the request if I am able to decide it conclusively. I haven't got the authority to decide anything for the board, and there were conversations back to you, and then they ended in my letter of September 30. And I don't have a time-stamped version of the appeal, so I was aware of the timeliness issue. But I guess the timeliness is I mean, I take it you're making a motion in addition to standing, in addition to authority.
Yes.
That the appeal should be denied on the basis of an untimely filing from the September 9th letter.
Correct. And even more so from the, and this is why Mr. Ballman could address this, from the original building permit for the work that was done there, which is dated August 25th, 2008.
Okay.
Not 9, 2008.
So that would be an additional motion. My understanding on that is that he has the ability to prove that he did not know or should have known of the permit under the statute. So if, for example, a permit or letter is issued and nothing is done on it and it's never made public, I think that that is an equity on that one point. But I now see four separate Mr. Schneller, I see four separate concerns, two raised by me, which is your standing and echoed in the Township September 9 letter, but which I personally am struggling with. Your standing to bring the appeal, and whether we have authority to do what you would like, whether this board has authority to do what you'd like us to do, and then in addition, the Township believes that you did not file a timely appeal from the September 9th letter within the 30 days, and you were advised in my letter of September 30 that that needed to be done, and also the board is questioning whether you knew or should have known of a permit issued in 2008 for 30 days, so that that in itself would be a preliminary thing. So there's two motions by the Township, and then on my recommendation, I suggested to the Township has moved to strike your appeal on the grounds that you didn't appeal on timeliness for two reasons. One, you did not appeal within 30 days of the September 9th letter.
Right.
Second, file your appeal. Secondly, that the permit is a 2008 permit, and you knew or should have known about that, long ago, and that you've missed the 30-day period after you knew or should have known for that. Those are the township's motions. The concerns that follow from the township September 9th letter, which I have echoed to the board, are: do you have standing, and do we have authority? Does this board have authority to do what you would like this board to do? So those are the 4 issues that are out there.
Mr. Schneller, on reflection, I think it makes sense to have Mr. Rice ask you questions, and then you can respond as you deem appropriate at the close of that. Would you
Yes,
have any?
if there's more questions, I'd be glad to.
Well,
Mr. Schneller, on the map that has been marked as T1, that accurately depicts the property that the work's been done on and where you live, correct?
I can't vouch for anything.
I can ask Mr. Baumann
but
about that
but
because
a
he,
visual representation, I don't know if it's to scale.
Okay.
Photographs are easily changed.
and how often, so other than that you live within a mile of the property, is there any other impact on you personally, any pecuniary impact, any interference with where you live that arises because of the permit that was issued for this property? Is there anything else, that would give you standing other than what you've already said?
Yes, there is an abundance of infringement on my comforts, my environmental comforts,
Okay.
my ability to traverse the town and the sidewalk. And I claim, if I could, some of my facts might come out more in argument, but I claim that, A, some of these are peculiar to me. I'm not complaining as one of the masses. In other respects, of course, there are the masses. And I claim, additionally, there's pecuniary effects because every time pedestrian comfort and shopper comfort is inflicted upon, it affects people like me who own real property in the vicinity.
But does this
And a
construction,
personal property.
does this construction that has occurred, does it stop you from walking through town or walking by this property at all?
Could I just,
Yes.
I'm sorry, answer the question. I'm sorry.
Yes.
It does, okay.
And as long as I'm making the point, it inflicts on the intent of the very township ordinance
Okay.
and master plan.
Okay.
And
There's-
how often?
Can I just interject one, because there's a case here that is a brand-new Commonwealth Court case that I think is very illustrative of what standing is, and I think is something that I'd like to see, with the board's approval, it addressed in its own terms. The case is Laughman, Laughman versus Zoning Hearing Board of Newberry Township. Was decided on October 9th, 2008, and published on January 5th, 2009. The citation is 964A2D 19. In Laughman, a zoning amendment was enacted in a rural township to put in an overlay which permitted a flea market. A landowner who owned commercial properties within 2 miles and residential properties within 0.8 of a mile challenged the ordinance, which this overlay allowed a flea market. And there was objection to standing, and the zoning board found that the appellant lived too far away to have standing to challenge a flea market. And in this case, they talked about pecuniary impact to the appellant as a landowner. Frankly, if something is done at King of Prussia Mall, it might impact my wife's enjoyment. I stay away from King of Prussia Mall as much as possible. I'm not a mall. I'm an online shopper. Nevertheless, we live too far away. It doesn't impact our property in Radnor Township. They also talked about, the appellant alleged that this flea market would produce more traffic into the township, which would course through the township and affect his properties. The board felt that that had not been, the court rather felt that had not been substantiated, but also cautioned that that kind of a harm was something that sort of dissipates among all the residents of the township, as opposed to the applicant's particular property. And again, we do not have taxpayer standing in the municipality's planning code jurisdictions. That used to be in Philadelphia, but that's been repealed, and the Supreme Court has upheld that. So to me, the test is, how does your property, how is how are you as a property owner or tenant or occupant at 500 East Lancaster Avenue impacted by the what is being done at 103 North Wayne Avenue? And moving beyond Lauman, in my view, I see this as very much akin to a mathematical determination. The factors in the equation are how intrusive is the use. I think that the radius for objecting to the construction of the Sears Tower would be much larger than the radius for objecting to a porch addition. But I still think you look at the intensity of the use, I think you look at the distance. And again, each of these determinations is a matter of fact, but at some point, even if they were to build the Sears Tower in the center of Wayne, I don't think as a resident of Garrett Hill that I have standing to object to that. And then in addition, there are topographic concerns that might play into this. For example, if your property is fronted by a park and they're doing something on the other side of the park you can see, perhaps the distance would be longer for standing than it would be if the park were replaced by several blocks of improved commercial streets. But it's a factual situation, and it does come back to how are you as an owner, tenant, or occupant of 500 East Lancaster Avenue as opposed to just a resident of Wayne. I mean, things come and go in downtown Wayne all the time, and some of them I would like to have seen stayed, but that doesn't mean that I've been impacted any more than the general public at large. The impact has to be direct, and it's got to be peculiar to you as a property owner, not just something shared by the public at large, in my view.
Mr. Rice?
Can I say something before it slips my mind, and that relates directly? I don't believe, and I've been researching extensively, and I don't think that the quote peculiar or the specific infringements one might claim well, since it slips my mind, I guess I'll return to questioning.
Mr. Schneller, just based on what Mr. Ryan just stated, which is a definition of standing, how does this activity that occurred on this property, how does it affect your property? What's the impact on your property? Not on your personal comfort level, but what's the impact on your particular property? Could you state that? And I won't ask you any more questions beyond that on the issue of standing.
Yeah, I answer that, but I reserve the right to make additional reasons besides the proximal property issue. And first of all, I had said that any infringement on property values in this township, in the vicinity or in the neighboring neighborhoods that revere this town as their shopping district, which is where the property I hold title to is situated, right, in Tredyffrin. Being a property owner, I gain aggrievement because everything is affected in some way. And if the WBOD is ignored in such a basic and outstanding way, that could only promise more of the same.
Mr. Sneller,
and
if I could
unto
interrupt
itself,
you.
I'm sorry.
Specifically, not talking about general philosophy or planning of Wayne. Specifically, how does this affect your property?
All right,
Dollars and cents?
I was quantifying that. And let me complete that particular point. I think that because there's a WBOD, that does widen the scope some. Now, personally, I would claim that my property within the quote metro region is being negatively affected by the decision.
Do you have basis for that? Do you have any real estate people here to back you up on that? Generally speaking, when there are good amenities in a town that enhances the value of a property?
Well, being non-expert but well qualified to answer, an amenity in Wayne has never been a problem. Wayne weathered 2 or 3 economic declines. I would say that the first on the latter, with all respect, is what really has been Wayne's problem. Comfort walking,
Mr. Schneller.
comfort parking.
Back to your property.
Mr.
Do you
Schneller.
have any problem walking around your property?
Wayne is a selling point for people moving into areas within 5-7 miles. Having a town center, people turn away from malls.
There is a town center. That's not the question. The question is, how does this affect your property, where you live, in your 4 walls, or
By,
your building?
by decreasing the selling points of the region.
Okay.
How, but you have not presented any proof to that effect.
Not, nothing documentary, no.
Okay.
Let me ask one question, Mr. Schneller. Can you, from your property, can you see 103 North Wayne Avenue? If you were to walk out and stand on the street, can you see the
No.
property? What's between your property and 103 North Wayne Avenue?
A combination of well-wooded lots, strip malls, road, and differently zoned neighborhoods of the leafy sort.
John, can I ask a question? Have we determined that there must be an economic impact for Mr. Schneller to have standing? Is that,
He has to be, the use complained of has to adversely affect his use and enjoyment of his property.
Yeah, it directly affect his thing. It could be something that, I don't think it necessarily has to be economic, it could be aesthetic, but it has to directly impact his property, and not just be something that's part of the general, if a great store goes into Wayne and everybody likes it, everybody in the township benefits. If a great store goes belly up and closes its doors and Wayne is perceived as less desirable as a shopping center, everybody, I guess, in the township suffers a share of pain. But that's a general, up and down for the township as a whole, and the problem has to be peculiar to Mr. Schneller's property.
According to
Well,
this particular issue, excuse me.
yeah.
Okay.
Well, forgetting Lawman, which I'm not sure I followed all of that, forgetting the 30-day notice, forgetting the building permit, if one, which and I'm the junior-most member of the board, so I know less than anybody, but if a citizen, which Mr. Schneller is, wonders, why is this railing up blocking what used to be open sidewalk, which I think is what your issue is, to whom does that party go?
Okay.
They go to code enforcement.
Okay, and then they get told it's denied, correct?
Right.
And to whom do they then go?
If
Here.
if it's a zoning code matter, they come to us. We do not hear appeals of decisions or violations of other township codes. We do not consider, for example, an appeal under the subdivision ordinance or the building code, or a violation of the township's rights and its proprietary rights and its sidewalks. The only
I disagree.
Take it up with the General Assembly.
I think the
No, I have time to argue, I assume, after my evidence.
Okay.
But that's what what would have to be done is to go through the proper channels. We can hear, and again, I think Grand Central Sanitary Landfill is very precise. We get to do what the code specifically, this board rather, has jurisdiction to decide and address the matters that the MPC specifically gives the board jurisdiction to address, and it has no further jurisdiction.
Mr. Schneller, do you have anything further to add on from an evidentiary perspective, on the standing question?
Yes, it's rather lengthy, but I have it in a list form.
And remember, my question was from an evidentiary perspective, not from a legal perspective.
Well, could I request that the timeliness issue not be granted any consideration until I have time to
Okay.
to go home, present postal service slips, et cetera, for the timeliness of this thing. And incidentally, I would ask that the evidence before us include A5, and I'm sorry I didn't bring copies, which is a affidavit of sorts, or a sworn statement, if you will, requesting, I filed it with my second letter to Mr. Baumann, stating, in case the zoning board ever hears this, please consider this. I'm requesting that we consider this second letter to Mr. Baumann, and of course the certificate I'm filing, to stand as a notice of appeal, because I'm afraid I might lose my right. And the appeal falls within 30 days of that request, in case there's a deemed
Okay.
earlier period of timeliness.
I'm sorry, first of all, the board can't take into evidence a letter that we don't have before us. Is there any way this letter can be found? Is this what you're discussing? The September 22 letter? You can take the document if you want. I mean, you can.
That was a response to the telephone conversation we had.
Yeah, but I mean.
I apologize then. What I filed, and I don't believe I have.
We got to move on. Okay, Mr. Schneller?
Anyway, I
Do
had
do
no
we need
notice.
any further evidence on the question of standing?
Now, please don't limit me. I'm prepared.
I'm not trying to limit you. We're trying to break this down in an orderly fashion. So the question is, do you have any further evidence on the question of standing? We'll get to argument when we get to it, but we're not there yet.
Well, I would hope it could come out with argument.
No, I'm giving you your opportunity to bring the evidence out now, so that counsel and anyone in the audience can ask you questions.
With all respect, I've never seen this done at a zoning board hearing. It's always somewhat of a free presentation. But let me see what I can put into the proper category. I believe that
I think that if I may interject, to the extent Mr. Schneller wants to testify as to matters of fact, that's evidentiary as well. If you want to testify that, you know, because of this activity at 103 North Wayne Avenue, you know, it's how it's impacting your property, that's fine. Argument
Absolutely.
as to whether what the law is or what the board should do or has authority to do or so forth, or whether, I've cited the Lauman case, but if you think that shouldn't apply, why it shouldn't apply, that's not a matter of fact. So your testimony is perfectly fine on the matter of fact, and the board weighs it like any, makes a decision how to weigh that like anything else. But we're talking about matters of fact, not arguments as to why things, why based on those facts, things ought to go somewhere else.
I simply noted that to my perception, board hearings are not limited to one than the other.
Excuse me, let me ask another question. Has it been determined that we have authority to hear this? Because
Well, we
whether he
need to
has
look
standing
at
or not.
standing
Let's
first.
look at standing first.
Okay.
Right.
Yeah, we have not addressed that issue. Okay. I've raised that concern, but we have not addressed that issue.
Let me address the other.
Could I?
No, wait.
We're on some preliminary issues still, Mr. Schneller, and I think that Mr. Schneller, at least what I've observed, he's done with whatever facts he wants to present on
Not so.
standing. Well, let me finish. I might be wrong. But the other preliminary issues are the timeliness issue, which is in front of this board. I've raised it on behalf of the township. So if I could just have Mr. Baumann briefly be sworn in. I have 3 or 4 documents to mark. I'd like him to at least also identify the aerial photo, since that is something that he prepared, so that that's clearly in the record. And then I'll be out of the way with what I would like to put in on these preliminary issues.
Okay.
If that's acceptable.
I think that's fine.
At this point, could I give 15 seconds on what's happened? The statements by various parties that the Stern application of some next-door neighbor infringement, I counter completely. I'll leave it at that.
I would like to call Mr. Baumann if he could be sworn in
Okay.
to address these issues. No, you can stay here. Is it acceptable if he testifies from here?
I think so.
You do solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, nothing but the truth.
I do.
And state your full name for the record.
Matt Bauman, I'm the Director of Community Development and the Zoning Officer for Radnor Township.
Okay, Mr. Bauman, the townships, we've marked Exhibit T1, which is the aerial photo. Could you just identify who prepared that and what that aerial photo represents?
I prepared that today, December 17th. That is an aerial, essentially, of downtown Wayne to the west, along Lancaster Avenue, eastbound into St. David's. I outlined Mr. Schneller's property on the screen to the right-hand side is 500 East Lancaster Avenue, and Mr. Beges' property to the west at 103 North Wayne. Approximately, the distance is about 3,800 feet, perhaps even closer to 4,000 feet.
Mr. Bauman, did you search the township files for any building permits that were issued for 103 North Wayne?
I did.
And what did you find? Did you find building permits?
I did. I found one issued that the Department of Community Development issued on August 25th, 2008, for an exterior alteration as well as an interior alteration.
Okay, Mr. Bauman, I'm going to mark a two-page exhibit as, that's acceptable. Can I mark this here?
Certainly.
Exhibit T2, and I guess I only have one copy. Should I show Mr. Schneller this first?
Certainly.
Yeah, Mr. Schneller. This is a two-page building permit with a date of August 25th, 2008. It's issued to 103 North Wayne. Property owner is 100E Partners. Contractor is S.W. Beges Ltd. And this is the permit report that is issued by Radnor Township Community Development for the same property on the same date, August 25th, 2008. I'm going to show this to Mr. Bauman. Okay? Mr. Bauman, can you identify what I marked as T2, Exhibit T2?
It is the permit, exterior alteration, interior alteration, issued on August 25th, 2008.
And is that the building permit for the work that has been performed at 103 North Wayne that Mr. Schneller is complaining about?
It is.
The other issue in terms of timeliness that I wanted to ask you about is the appeal tonight. Mr. Schneller submitted Exhibit A3, and that was Mr. Ryan's letter to Mr. Schneller about the 30-day appeal period. Your letter of September 9th that you issued to Mr. Bauman.
You mean to Mr. Schneller?
I'm sorry, Mr. Schneller. And the appeal, when was that filed? Do you know when Mr. Schneller's appeal was actually filed?
The original appeal?
This appeal tonight, the one.
It was filed on October 16th, 2009.
And how do you know that?
We have a receipt in the folder documenting that.
Could you, if you would go find that folder for me and show the board and Mr. Schneller where that receipt is?
No problem.
Could I ask you a question before you go and find that? I don't believe it was you probably that issued the permit, but when the permit was issued, did any plans accompany the request for a permit?
When initially was submitted, yes, there were.
Okay. Is it
We would not have issued the permit without first looking at great length to the type of activity occurring on that site.
So some sort of blueprint or floor plan or something to that effect?
Correct. They would have to be stamped and sealed by a registered engineer or architect.
All right.
Was there anything in the exterior plan relating to a fence?
Not at that point, I don't believe so.
Would that have normally had to been a part of the permit to allow that fence to be built?
I want to be careful that this is not considered a fence. It is a guardrail. It is handled through the IBC, the International Building Code. It is a railing. It's protection so people do not fall from the grade separation between the adjoining property there. So the zoning permit was not issued for this.
Mr. Baumann, are you saying then that this permit was not issued pursuant to the zoning code, but pursuant to the township's building code?
Correct.
Okay, so this is not this township is not processed this as a zoning code matter. This
Correct.
particular rail is a building code
It's
matter.
a building code related issue.
Was the grade separation part of the building permit? Because
We're without
there was
subject matter
there was no
jurisdiction.
grade separation prior to.
That would have been submitted with, when the sidewalk was completed, or the grading permit through engineering was submitted in approximately May of 2009.
When was is there any representative of the landowner here tonight? Okay. I guess, well, we'll wait till they're sworn in, but do you know when the construction was done? Do you have any idea, does the township have any idea of when this railing actually was put in?
I don't know the exact date, but if the grading permit was submitted in May of 2009, I'd imagine.
I got to object. There is no grading permit.
Excuse me.
Yes, there is, Mr. Schneller.
Don't argue with him.
Okay. I think I'd like to withdraw that question, and if the township doesn't know precisely when that was built, perhaps that's best asked to another witness.
Okay. John, do we have subject matter jurisdiction at this point?
Well, I think the permit the township's alleging that it's not a zoning issue, and unless somebody can allege that this is a zoning issue, we absolutely don't have jurisdiction. I would agree with that. And as I've expressed my concerns before, there are a number of things in here. We don't have the authority under the MPC to perform an investigation. We don't have the authority under the MPC to issue sanctions, cease and desist orders, or any kind of enforcement. We can't fine anybody. We can't order anybody to stop doing anything. We also, one of the comments in there, which I think I alluded to before, of a town commons, that's an issue of title. Who owns it? Who has what rights? Zoning boards have no authority to adjudicate private rights or issues of title to real property. That's clearly beyond anything we can do, and there are cases on those points.
So we would not have subject matter jurisdiction over the merits, but we might have jurisdiction over whether or not Mr. Baumann's conclusion as to standing. We may be able to determine that question.
Yeah, I think that we have I think this board has jurisdiction to determine standing and timeliness, because those are part of any issue. But
right.
Candidly, if we're talking, I think the other one's important too, because if we're talking about proceedings in areas that we're not authorized to conduct proceedings, we're outside of the board's outside of its jurisdiction.
I would have some evidence to present an argument concerning the subject matter jurisdiction, that being the second point about the authority of the township in any respect in your letter.
Mr. Baumann, would you mind getting the permit?
Could I ask that if there's plans associated with the
Which permit?
The one that he was going to go get a few minutes ago.
Well, what I had asked Mr. Baumann was to just document the date that this zoning hearing board appeal was filed. There's a receipt in the file that Mr. Ryan has.
Oh, okay.
And I just want him to identify that for the board.
And if I could testify while he's gone?
And I apologize for not having copies, but I just trying to determine when this appeal was actually filed with the township. None of them have a timestamp on them. And so, Mr. Baumann, is there evidence in the file, the township's file, when Mr. Schneller's current appeal was filed with the township?
Yes, it's October 16, 2009. It is receipt number 202437.
And that is a receipt for what?
For submittal for the zoning hearing board appeal number 2820 for property located at 103 North Wayne Avenue.
And that's a receipt for the application fee, is that right?
That's correct.
Okay. That's all I have with Mr. Baumann.
Mr. Schneller, you have, you've entered into the record as A3 my letter of September 30th, which was sent to you by regular mail, certified mail, and email. I know for a fact that the certified mail was not signed for because that was returned to me. Did you get this letter?
Yes, I did.
When did you get it?
I can't say, but I have the envelope at home. I'd say it's probably irrelevant because I mean, from my point of view, because I then responded. And if I could say very simply, this is the basis for my timeliness, is the fact, A, that these were continuing matters. There was a August turn down of my notice of appeal. I wrote of my request for resolution of essentially the same matters. There was a response from community development. I responded again. I then filed a notice of appeal. I then received a letter from Mr. Ryan. I then, before filing a notice of appeal, rewrote and simply put with the letter, and I apologize deeply for not having this here. I hope it's in the file, if you could locate it. It is a affidavit. Well, it has to be a record.
It's not in my file. It's not in the zoning file.
Well, I've got all the United States Postal Service proofs.
Okay. It's not here in the record. And wasn't with your application, right?
It certainly is not with my application. It was filed before this.
Okay.
Not being part of the appeal, it may be harder to locate. But it is a sworn statement, and it simply says, this is my second letter. I'm trying to resolve this. Can I get some kind of determination from the zoning officer so I can file an appeal? I suspected I wouldn't get a response. I included this sworn statement that said, I request the township to consider this day, the day you received the letter seeking for a second time a statement of any kind from the zoning officer, consider this day a day of appeal.
Okay. Okay.
And then my appeal was filed to my personal knowledge within 30 days of then. And another major point I would say is the fact that this began within 30 days. My first letter to the zoning department occurred within 30 days of my seeing this project and not seeing it completed within 30 days of I believe, the grading and the finishing cement.
Mr. Chairman, if I may make a recommendation, there are two issues that I can't see how we cannot decide with what's before us right now, which is standing and authority. We have a lot of back and forths and when were letters received and so forth. I do think that the September 8th date I'm more persuaded that it's when Mr. Schneller knew or should have known about the construction of the sidewalk. But the point of the matter is, I don't think the board needs to reach the timeliness motions unless it proceeds past standing and authority. If we have no if Mr. Schneller has no standing and if we have no authority to do anything, then it seems to me those motions are moot. So I would suggest we defer the timeliness motions and preserve them, but first decide the two issues of standing and authority.
Okay. Mr. Schneller, let's hear your argument on standing and authority.
First of all, as to standing, I would like to state that it's been said that the quote fence was not a fence, and having not a photograph, I present that this is a fixed wrought iron object. Someone has to testify to it.
That's not relevant to standing. Let's talk about your standing.
Well, it is, because this would have a much greater infliction on my use of the sidewalk than were it a guide or some kind of temporary fixture. As has been mentioned vaguely, there is a grading that occurred, which has disrupted, and of course being enclosed by a fence, finishing off that disruption, what was formerly approximately 15 square foot, 15 by 15 plaza, which had a park bench for at least 30 years of my life. There also are And I did ask for plans. I'm sure that this description will do for now. There are 2 trees directly in front of this location, a hydrant, and 2 parking meters, all within the typical distance of the street. I traverse the street and the location daily, year-round. I witness people constantly having to step aside now, not having the free use of what was quite a valuable plaza because it is our last. There'll be other facts, I'm sure, arising as I speak. The township, Mr. Ryan's citation of Grand Central is clearly only related to a board that went back on its former decision. And to my knowledge, that's very true. You, unlike most other bodies, cannot really go back unless there's good reason, and certainly not on a whim or one person's testimony.
Actually, there was very good reason in that there was allegations of fraud by the applicant. They still didn't have the authority. The reason I cite Grand Central Sanitary Landfill is its reasoning. The reasoning in that case very clearly states that zoning boards have to have the express statutory authority over a matter in order, and if the statute doesn't give the board jurisdiction, then the board can't do it, even if it's for a good cause.
Right. To which I say that I've brought along the section of the code, and the Radnor Municipal Code itself has bearing on this. And allows in 2 sections or more, if I could cite from section 280-157. This is jumping ahead, but you'll get the picture. 280-157 deals with, quote, causes of action. And it states, in section B, in case any building, structure, landscaping, or land is or is proposed to be erected, constructed, reconstructed, altered, converted, maintained, or used in violation of this chapter, the Board of Commissioners or the zoning officer or any aggrieved owner or tenant of real property, and I note tenant, who shows that his property or person, and I note person, will be substantially affected by the alleged violation. And the section goes on to give remedies that this citizen or the board or the zoning officer may institute any appropriate action or proceeding to prevent, restrain, correct, or abate such building, structure, landscaping, etc. So not only do we have here references to infringement on person, my person is deeply affected. Mr. Ryan's other authority, Laufman, is one of a few that tend only in the last 5 years to relegate the word aggrievement to a simple next door proximity. This was never intended by the code. I won't get into lengthy reasons why, but certainly a citizen who walks down the street every day does have some aggrievement, and under my circumstances, which you're about to hear, I think that cumulatively, if not on that sole basis, I am an aggrieved party under the code.
I noticed that 157B talks about appropriate proceeding, and there may be other avenues for you to proceed, but the zoning board only has the authority to do what it can do, and standing is done by by the code itself of aggrieved person, and it's case law, which is clearly said it's got to be an impact of the landowner who's close enough to the complaint of use to, based on what it is, to be directly affected. And
well,
we're bound by the case law. One of the things, unfortunately, is we're bound by the case law. We have,
agree.
The case law might be all wet or not, but we're bound by the case law.
There's just an abundance of case law still out there that says that I'm an aggrieved person.
Okay.
And as to the fact that there is no more taxpayer standing in this state, I would again have to disagree. I have taxpayer standing.
Do you have a citation for that proposition?
Yes. If I could just be general, standard practice in Pennsylvania, section 14:25. Standard Pennsylvania practice, second 14:25. Describing the so-called Beaster taxpayer standing. And the reason I really invoke it, not just because I read it out of a book, is because otherwise a, quote, governmental action would go unchallenged. So a taxpayer, quote, may be granted standing to challenge that action. I realize this could apply to anything, and I hope you will check the citations. This even applies at times if there is a common interest with the citizenry, but it is improbable a party would challenge the action. And I have claimed, and claim again now, that there is not only a feeling of what's the use in this community, but there are elements of fear and elements of not wanting to attend meetings. These meetings.
Mr. Schneller, you're going far afield now. That's not at all relevant to whether or not you have standing.
It's relevant because no other party stood up.
Okay. Do you have anything else on the standing question?
Yes.
Please make it brief if you don't mind.
I'm sorry, but I came prepared to tell my reasoning. And the initial fact that I believe may cause me additional aggrievement, and the reason why the board has subject matter jurisdiction is because one of the sections of the Municipalities Code, I still can't get it right, the Planning Code,
Municipalities
MPC,
Planning Code, MPC.
is not an aggrievement by proximity. In fact, proximity is not stated in the statute anywhere. However, another reason given is, this is Title 53, Section 109(16.1), is that a citizen may appeal any determination of the zoning officer. Now, you have to know that I'm appealing not only determination of the officer, but it's a concrete decision. I didn't walk in and say someone's dog leash is 30 feet too long. I walked in with a concrete set of reasons, and they include violations of the zoning code, the overlay code, and feasibly the long-standing municipal code. So there are violations of the zoning code, to my knowledge. Furthermore,
Which precise sections of the code? 916.1, by the way, is whether the zoning ordinance is valid, not whether there's been a violation of the ordinance. But what specific zoning code violations do
you know
you?
the jurisdiction section?
Wait a second. Wait. We don't have to go into that right now. We're talking about standing.
Just to correct the record.
Let's be clear. Let's wrap this up on standing, and let's move on to the next issue.
I'm afraid we're getting to the merits, and I
I don't want to get to the
don't
merits
think
until
it's
we wrap.
necessary. I've stated these violations.
Okay. Do you have anything further to add on standing?
Therefore, because the board originally looked at each other when I mentioned this, I had no choice but to write the zoning officer to try to get action. I think everyone who walks North Wayne Avenue wanted to do something. I'm not talking about this board. The Board of Commissioners literally looked at each other, and I received not a single verbal comment. This was at a public meeting on this matter. And I, therefore, as a concerned citizen, have followed the pathway that I'm supposed to, and I guarantee that I have researched it as I went.
Okay.
Furthermore, I am quite certain that this body has the power to investigate or at least to issue declaratory judgment. I understand that there is a power to look at statutes at the municipal code and make determinations, but it is much wider than that. The zoning hearing boards in the case law have been given authority even to, quote, investigate, but more so to make determinations, to give word back to the zoning department how they should handle something.
Can you
are
show me
not
a case
bound-
where the zoning, cite me to a case where a zoning board was given authority to do an investigation? Do you have a
Well-
citation for a case which said that zoning boards have the authority to conduct investigations?
No, I'm sorry I don't, but what they did was they were a case before a Board of Commissioners, was, and this has happened many times, was directed to the zoning hearing board to get the factual circumstances. Now, the zone,
What specifically are you talking about? Radnor Board of Commissioners? Or-
Yes.
And, okay, when did that happen? And what was
I
the
don't
subject
recollect.
matter? Okay, then that means nothing. If you don't have concrete information, it means nothing to us.
well, that's what the zoning board is for, though. For instance, you just directed
I
Mr.
think
Baumann to
Mr.
get plans, and I think that's...
Mr. Ryan stated in the beginning specifically, I think it was 3 or 4 sentences, specifically what the zoning board can do.
Well, I disagree
There's a
with
lot
him.
of things that we would like to change in the world,
No,
but we
I'm-
can't.
I'm not making up the law.
Okay, Mr. Schneller, do you have anything further to add in terms of argument?
Yes.
I think the ground is very, very well plowed at this point.
The distance of 3,780 feet is in no way limiting to the aggrievement of a party.
Okay.
I'm in possession, or I'm looking at a citation where an individual lived 6,600 feet.
Specifically, what is it talking about? Not just you're looking at a citation. What is it?
Is it a case that you're looking at?
Yes.
What is
I
the
have to say
case?
that, An authority.
What's the case?
For my 6,600 feet here. This is typical. I will backtrack and first of all state that there
Do
are...
you have a copy of the decision? If you have a decision, we need to see that.
If I could kindly backtrack and wait till my vision improves. There are numerous cases that work with a distance of blocks. Now,
Mr. Schneller,
Yes.
we need specifics. You're generalizing too
Right.
much,
That's why I've digressed, because I have specifics for these.
but you haven't been able to give it to us. Specifically, what case says 6,000 square feet?
And I
Or-
stated, I'm in the process of trying to verify where it is. Certainly the board, if such urgency kept on, would allow me a day or two to file a brief.
You've had 2 months.
I disagree.
And an hour and a half.
Well, I've withstood this sort of pressure on the stand here, and I object.
Okay.
Now, let me
What
give-
else do you have
let me-
in standing?
Let me give my 5 cases that
Do you have numbers and names on the cases? Probably our attorneys would be familiar with.
yes, and frankly, if you plug into your research mechanisms,
Can we
the
just,
figure 6,600
no.
and aggrieved, it will pop right up.
Okay.
Okay, give us the numbers of the cases.
All right?
For the record, Mr. Ryan did instruct us that distance was but one factor to be considered.
Absolutely.
Yeah.
That's the important thing, is that there is not a cut and dry science with aggrievement. And frankly, standing here and the board having witnessed me here before, I hope that the number one point of my verity and my sticking to the truth might register at least some weight as far as your decision.
I don't think anyone on this board questions.
That was just one of my points down the list. Although this is a citation, and the authority is SPAHN, S-P-A-H-N versus Zoning Board of Adjustment, 922, A2nd, 24. Although a resident lived approximately 1.5 blocks from the lots and walked by them every day, his only expressed interest in the case was to see that the city's plans for orderly development were not undermined. I mention this because this is one of the few cases before
Well, Spahn actually just went to the Supreme Court, and Spahn is not a helpful case. Spahn stands for Philadelphia used to have a rule that if you were a taxpayer, you could appeal anything. And that was different from the MPC, which is where Radnor Township is located. The state legislature amended the Home Rule Act for Philadelphia to delete taxpayer standing and put Philadelphia basically on the same footing as the rest of the Commonwealth. And the Spahn and Scrub decisions, which are the companions cases to Spahn, stand for exactly the proposition that we've been talking about all along, as reflected in Laumann. You've got to have you have to be directly impacted as an owner or resident by the use, and general taxpayer standing or desire to uphold the law, however laudatory those may be, do not give one standing.
Yes, and I say that, as I said earlier, Laufman is a set of very few cases, and I have validly argued the fact that this trend in Pennsylvania law is sparse. It shouldn't have been applied to me ever. And my arguments before the Commonwealth Court, I'm reading from my Commonwealth Court brief.
We honestly.
But you've got to hear this.
But they're not. But they're not. But your arguments before the Commonwealth Court in connection with other matters, that's not relevant. If you want to argue the law as it applies in this case, that's one thing. But only as it applies in this case. We're happy to hear that.
And Spahn it does not stand for taxpayer standing. It stands for exactly the opposite.
Yes, but that's my point. I was going to get to that, is the fact that rather than apply the common to all citizens argument, this fellow just made a vague claim. And the very few cases, including Laufman, never get into nuts and bolts because they don't want to, because there's no such law. Distance itself can never be the criterion.
No, I agree.
It's
It's a focus of distance, intensity of the use, and other factors like intervening topography. But at some point, there is an area where, for example, an immediate neighbor would clearly have standing. And there are areas where the board can make findings, but at some point you're too far. And there's, no matter what is done, I live in Garrett Hill. They could build a Sears Tower, they could build a nuclear power plant, they could do whatever they want at 103 North Wayne Avenue, and I have no standing, period, under any conceivable fact-finding latitude given to a zoning board to appeal what's going on in Wayne as a resident of Garrett Hill. Just don't have it.
Well, do not forget, I've just made a point that I'm challenging a decision by the zoning officer. There is a written decision, or a lack thereof, by the zoning officer. I didn't just come in and say, I'm aggrieved by the changes to the street. There is a concrete second reason. As far as the 6,600 feet rule, the authority cited is, the authority goes, resident living 6,600 feet from a site was an aggrieved party.
Okay, what was...
Grant versus Zoning Hearing Board of the Township of Penn, Penn Township, 776 A. 2nd, 356.
Okay. What was the use that there was being complained about?
I have read the case, but I don't recollect. As you know, they're usually of something rather substantial if they made it into the published law. And that is, of course, probably a well-known case to some of you. Quote, the fact that the complainant before the Zoning Hearing Board was not the owner of the property did not automatically deprive him of status as a person aggrieved. That's V.A. Check versus Zoning Hearing Board of Hazel Township, 1996 case, 676 A. 2nd, 1317. Likewise, in V.A. Check, the Commonwealth Court
Mr. Schneller, you're not going to read your memo, your brief to us, are you?
No, I'm on the sole page I underlined.
Okay.
Likewise, in V.A. Check, the decision was made that the adverse pecuniary effect is not required to establish standing. So my statement that the Township Code, in saying affecting a person's property or person, is backed up by the law to this day. Finally, as far as the law is concerned, there is a case called Rouse. It was about the Rouse development intended to be built out next, which was turned down. And a group of people, neighbors, people bordering on a stream, I believe, or a creek, made a large case and a lot of noise about the fact that the creek and their surroundings in general and their visual obstruction was going to occur from a large housing development. Well, they were roundly tossed from the court. However, again, the court gave us this general term. They didn't go into why. They said this is something common to the populace and it's something speculative. Now, my complaint, speculative, Mr. Ryan might agree, is a word used in these up-to-date decisions, probably even Laufman.
Okay.
I am not speculating. I walk this corner. I have to rub against this fence every time I'm passing someone going down the street. I'm forced to watch a very pleasant plaza, which already has the trees, turned into someone's private use against the zoning code.
Okay.
In a case, and this is my last citation, the Acorn versus Zoning Hearing Board of Upper Merion, 1987, 105 Commonwealth 138, really prevented community groups, quote, from making any kind of appeal to the higher courts. So community groups have been forestalled and reluctant and afraid to appeal anything since this opinion came out in '87, more so and more so. And I know you can't do anything about it, but I think this restrictiveness is awful. But more so, if a community group won't come in, and I don't think a community group has stood before you in a couple of years, and that would be the reason why, and the community group hasn't sued.
Again, Mr. Schneller, we're just way off the reservation again.
No, because
I'd like to have a continuing objection to Mr. Schneller's tirade.
Okay.
I mean,
Mr. Schneller, if you could wrap up very, very quickly and succinctly.
well, I thank you for being patient, because this is.
I think to the extent Mr. Schneller is arguing law, which a lot of this is, that's argument, and, you know, the township will have its opportunity to do so as well. And as to facts, I'd like to, you know, I think we've gone past, we've covered the facts that are there.
I think we get it.
I think, oh, no,
Believe me, I think we get it.
if I could just go on for a short time. The fact that the Board of Commissioners has directed or permitted Mr. Rice to be here is an indication that there is import to the substance of the appeal. And
I don't think we can read anything like that. You've challenged, the zoning officer made a decision. You've challenged it. The township is perfectly entitled to defend the actions of the zoning officer. I don't think there's anything nefarious to be read into that.
I also am forced to question the Department of Community Development's decision not to simply let the appeal be filed. What we've done is add a layer here, a layer of.
Wait, I understand your concern about that, but we've been going on for a really long time. We have other matters to get to, and so let's move
appealed
on.
that properly.
Let's stick to the matter at hand. And the question before you is?
Standing, I believe, still.
Mr. Steller, you made
Yes.
the comment that you have to brush up against the railing. How wide is the sidewalk at that point?
To my knowledge, it's 4 feet.
Okay.
All right.
A permanent change has been made
I just asked the number, that's all.
based on the code allowed for temporary sidewalks, temporary cafes.
Okay. Mr. Schneller?
Yes. Oh, further as to standing. The master plan, if I could be very, very brief, and we all know that the master plan is somewhat wordy. It's a rather rather
excuse me, no.
relevant
No.
document.
The
No,
master
master
plan-
plan is irrelevant. I think we've heard, I think,
Well, if I could simply state, the master plan applies strong incentives for certain things, and it's my claim that this has gone against the plan. And
But the master plan cannot give us, this board, jurisdiction that it doesn't have. It cannot give any party standing that that person doesn't have.
Yeah.
The master plan isn't even an ordinance, but it certainly can't change the rules of standing or authority.
right, okay. Mr. Schneller, I'll give you 1 minute, and then we're going to move on.
may, please the board, I'm not making public comment. I don't think it's appropriate that I
Well-
be hurried.
Well, I don't believe you've been hurried. It's been over an hour and a half.
I believe
We
that
had- We've heard your arguments. We've heard your presentation of your evidence. I don't think we've limited you in any way in that regard.
I'm still giving evidence, and if we added up the comments to hurry, we'd have an additional 15 minutes at this point. I'm being forced to present a choppy and what would appear maybe to an appeals court tirade type presentation. I mean, this is very unbecoming, and I think if I could just complete, it's not going to be
Mr.
another-
Schneller, in due all respect.
And now to continue it
no,
is
no.
simply to continue it.
The chair has to run this hearing tonight. I believe that
Yes,
this
I
has
am no way
been
opposed,
done.
and I submit to the chair's authority completely.
Okay, and I also
has to
think that,
go.
that this hearing has been conducted, with a full desire to give everybody a fair shake, but, we do have to move it on. I don't think that there's been any defect at all in how this hearing's been conducted.
And we have had the benefit of your memorandum of law as well.
There are clear-cut statutes that would have had to have been followed by the constructor, including design review board approval, shade tree approval.
Neither of those items are matters
No.
before this-
However, I'm allowed to include them, including towards standing, because the board is my only place to turn. And I don't think the law is going to turn up an authority that I can't come in here with anything but a strict, want to change my variance appeal. Maybe you haven't seen one in a while. So I mentioned shade design review, and naturally, Section 15 of the overlay, the Wayne overlay, dealing with sidewalk cafes has been transgressed considerably. I would argue other sections as well, including Section 7.
We're getting into merits now, aren't we? Yes.
It strikes me, Mr. Chairman, I think we've heard the standing arguments. We're getting into merits. Perhaps we should hear from other people in the audience or the
Agreed.
township as to what they feel about the standing issue.
Thank you, yes, I concede my stump here, and thank you for putting up with the arguments and facts I presented. They relate, however, only to standing.
Understood. Mr. Rice?
I'll be brief. I think it's clear Mr. Schneller has no standing. I respect his right to file his appeals and raise questions, but we all have to follow the rules. The rules are pretty clear under the municipality's planning code and the case law in terms of what consists of standing to file an appeal. You can't file an appeal and get standing because you happen to walk past the property once a week, 5 times a week, 30 times a week. There's no impact on his property. To accept that argument would mean that every building permit in Radnor Township he can file an appeal on. And he's making an effort to do that. And
Object.
he will continue to do that with anything that he disagrees with. And I think this board needs to send a clear message that these appeals are unproductive. You have firm basis to dismiss this on standing, on the issues that he raised in his appeal, which are really just questions that he could get answered if he walked in the front door by Mr. Baumann or one of the other staff. He may not like his answer, but he'll get an answer to those questions that he raised.
I didn't get an answer.
Instead of doing that, he filed those questions as an appeal. There's nothing in there in that initial appeal and those questions that fall within this board's jurisdiction. Has the right to appeal Mr. Ballman's letter saying there's nothing in here that's within the board's jurisdiction, and that's what he did. So you had the basis to dismiss this case right now on those two issues. On the timeliness issue, I understand, Mr. Ryan, that the board may defer that, but I think that's a very clear issue, too. At some point, when a permit gets issued and someone notices that there's been work done, you can't wait a year to file an appeal. Building permit for this property, just putting aside whether or not this board can even hear building permit appeals. There's a whole separate appeals board for building permits versus zoning permits. If there was a zoning issue, as a result of the building permit, he should have filed that within 30 days of the building permit or when he knew that there was work being performed on the property. The other timeliness issue is the fact that he had 30 days from Mr. Bauman's letter of September 8th, 2009 to file an appeal, and he didn't meet that deadline either. So I think you've got plenty of reasons, legal reasons, that to support taking some action at this point. I'd like to move for my three exhibits to be entered, too, T1 through T3.
Okay, they're part of the record.
And that's all I have. Thank you.
Okay, thank you. Does anyone in the audience have any comments? Did the property owner want to make any comments with respect to this appeal? Sir, if you'd be sworn.
Can you raise your right hand, please? You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes.
And state your full name, please.
Joseph Birch, B-U-R-C-H. Sure. I work for S.W. Bages, who did the work for this property. It's one of our partnerships. We did get a,
If you could speak right into the mic. Yeah, you're
Okay.
good.
we did get the building permit. I forget what the date was. And then later on, we did get the sidewalk permits, which were May 5th and I want to say May 6th.
Thanks.
I do have copies.
Was that this year?
Yes, May 5th, actually May 4th and May 5th of this year. The department made me pull two separate permits because what we were doing was along North Wayne Avenue, we were putting in the Wayne sidewalks with the brick pattern, the 2x2 squares, and then within the body of coming off of the building, it's a different pattern. It looks different. We didn't follow the same Wayne sidewalk into that area. Also, as we work with that building, you have to remember from the left side to the right side, you have a fall of about 33 inches on that property. So not only are we trying to improve the property in conjunction with the Wayne site amenities, we're also dealing with ADA issues. This building, before we bought it, you had to take a step up into it. So one, we're trying to make the sidewalk as compatible and easy to walk along there, but then also from the sidewalk, we have to then, without going against ADA, which now we can't have more than the 5% slope, it can't have a pitch of more than 2%, have that sidewalk then meet our building and not have a step up into it. So there was a lot of work that went into this and in trying to figure out everything and not exceed the pitches that were permitted with what is not normal. We also submitted a plan that was done showing those various pitches. This is actually a copy of the plan that was submitted to the township, and they have the plan. I can give this to you. But on the plan also, we knew we were going to have differences because as you're coming off of the building, you have certain pitches that you have to abide by. I'm trying to meet the left and right side of the property. That's not me, sorry. And then actually on the plan, what we wrote in there, I can give it to you. You see it, I think on the microfiche, it does say wrought iron fence. I mean, wrought iron railing. So that is what we put in there to then create the buffer between the two.
When did you put in the fence? I'm sorry.
Just following up on that, I don't have that information exactly. What I do have, I have a copy of the receipt for the completion of the sidewalk, of the concrete work.
Would that
and
have included the
receipt
fence?
Was June 25th.
Would that have included the fence?
Not by the concrete guy, that was done by a separate person. But that was definitely the completion. I would say the work was done earlier than June 25th. The concrete was done. Once all the pictures are done to do the heights and all that, then the railing guy comes out and measures from there.
Okay, so basically the concrete was in there to take care of this drop, and that was in place sometime in June, and then the fence went on at some point after that.
Correct.
Could I see that plan, please?
Sure.
Would it be possible that the railing went on
Thank you.
after July, or is it likely that it was put on in July? Sir, would it be possible that the railing was put on after July, or is it likely that it was installed in July?
Just for safety of that, because remember, we did have, as you would come down North Wayne Avenue, there's a drop there of about 24 just into the lower area. So we would have had that being measured and going up as soon as possible. At worst, I'd say no more than probably a month to put that on, but I don't have the exact date.
Can you testify that the fence was up, say, by August 1st?
I don't know for sure.
Okay.
I would have believed.
Another question, from this drawing, does this, are we interpreting this correctly, that the fence does not encroach the building 101? Does it go in front of it?
No, it does not.
West? Okay, so it's behind, it's no greater than the building that's there already,
No closer to the sidewalk.
no closer to the street.
No. And then actually what I kind of follow up on, I think what you're,
No. The, there's a
gotta mark
line.
these.
If the
Whoa,
merits,
whoa.
Okay,
if the merits are
What-
going to start to mushroom, what about the hurry the board was in?
the dots that are line, and then there's little dots on that plan, is that where the fence is?
yes.
Okay.
To kind of give you an idea, the Saldo regulations are for the curb, 24 inches of the brick paver, and a minimum of 4 feet of the sidewalk. And what I just kind of handed to the chairman and also to Mr. Schauer is kind of a picture of our sidewalk there. And the minimum size for a sidewalk for Radnor Township from the township is to make it 48 inches. Our
Can you
sidewalk
move that
from,
more to the center of the table?
There you go.
Good.
from edge to edge of our sidewalk area is actually 50 inches, which is a little bit larger than the 48. This is 103. And to give you an idea, I took a walk around Wayne. This is in front of the Paisley Shop and Pie in the Sky. And one of the issues with the way sidewalks are, you can't have any encroachments or a change in the material, so it has to be a continuous sidewalk. They don't really count the brick paver because that is a change, although you can walk on it. For ADA purpose, they don't include it. So in here, what you have is the sidewalk actually gets closed down in front of 102, 104 to 40 inches, which is actually less than the recommended 48 inches. The concern is if there's ever a blind person with a dog and someone coming the other way, they feel 48 inches is clear for two people to pass, but this obviously gets lower than it.
I think Mr. Chairman, and I'm not trying to rush you and say it's a bad thing or a good thing or indifferent thing, but I think we're on standing and authority right
Agree.
now. It's nice to know what you did, but I think now I would respectfully suggest that we focus back on
Agree.
standing and authority. You obtained a permit for this work, the concrete and the fence?
Yes.
Do you know what code that was issued pursuant to?
Which section of?
No, which part of the code? Was it a zoning code, building code?
I believe engineering,
Okay, so-
engineering department, or they're in the same part, community development or engineering.
Okay, so you
They
don't know the
handle
code
sidewalks
sections. You don't know
but
the
I don't know
code
exact.
sections. You don't know the code sections.
It was through the engineering department. It's not a community, grading is not through community development.
Okay.
Which department did the final
In other words,
inspection?
I'm
Yeah,
sorry.
We're going one at a time.
In other words, it's not zoning.
Yeah. Okay.
Yes. Engineering. And actually, during the course of the work, I met Dan Malloy, Doug Nieder, and one other person who used to work for the township at one point as we went through it to look at it and understand, because it is a little confusing with all the pitches and the heights. And
Okay.
we met on site and then proceeded and finished the job even after that meeting on site.
Okay. Anybody else have any questions?
Yes, just wanted to make clear, the reason why I asked the width of the sidewalk, because Mr. Snelling said that one of the problems was that you had to brush up against people and it was uncomfortable. It appears from your plans that this is the same width as the sidewalk that surrounds the corner building, and you're continuing the same width. That's why I asked those questions.
One quick thing, actually, if you go north, either way from our property, just north of us, 109 North Wayne Avenue, it actually shrinks down to 34 inches, which is less than my 50 inches on our property. And if you went the other way, the corner property along Lancaster Avenue, there again, it shrinks down to only 36 inches. Again, as you proceed north, we are actually wider continuously throughout the course of our sidewalk
Okay.
than any property north or south. So in order for him to enjoy our property, he's had greater infringements prior to us, and we are actually wider than everyone else around us.
Would you like to have these exhibits entered into the record? We'll probably need to mark them. I would suggest, LO for landowner, and then 1, 2, and 3.
They're numbered in the bottom corner,
Oh, they are? Okay.
Yes.
How did you number them?
1 through 8.
The photos each have,
Okay, so I would submit that they be marked,
And the
LO or
plans.
O or something like that for the landowner. And
mark the photos, landowner 1, and we'll mark the plan, landowner 2. Okay, any other questions for the witness?
Just if you're, I guess, submitting stuff, I also have copies of the permits, which are permit number 5607 and 5608 that were issued on 5/4 and 5/5.
Can I see those?
Cross-examine?
Yeah, when it's done, yes, you'll have the opportunity to cross-examine.
We'll mark them landowners 2 and, 3 and 4.
I notice that these are applications for highway permits, which I assume is a permit for work on the township right-of-way. Is that the case, Mr. Rice? Or Mr.
Well,
Vaughn?
it is, but it's for application for a state-owned road.
Okay, so it's a state-owned.
Correct, PennDOT.
It's not a zoning permit application, and those are not zoning permits.
It is not.
Okay. Mr. Schnell, you had a couple questions?
I'm sorry I interrupted Mr. Burst, but you may have gathered that sometimes you have to get in word while you can at these hearings. I'm looking at application 5608. Did you sign this application with your title as VP Real Estate?
Yes,
So you hold a position within the firm itself that's going about the renovations to the
correct.
property?
Yes.
Thank you.
Any other questions? Anyone else from the audience have any brief comments? Okay. Mr. Schneller? Anything further, briefly?
Yes, can I please point out that on application for the sidewalk, number 5608, please tell me if this is would I be permitted to inspect the submission? I only got copies, I believe, of photographs.
Sure.
Yeah, come on.
I am holding the that application 5608, which is for, quotes, construction of sidewalks, is the one I just questioned the participant about. And if we could put the second page on the camera, I just wanted to point out that there is no plan given. This was stated to be this is the only plan, to my knowledge, on file for the actual laying of sidewalk at this property. I'd hope that that community development might be able to verify that. And I'd like to point out that there's no trees, there's no specifics of the location given.
That to me looks like design rather than a plan as to what it's going to be and where it's going to go.
Yes.
Okay.
However, it's the only one on file. And to my knowledge, it's the only one on file concerning grading. When I questioned community development about grading, about anything past 5 feet from the curb, 3 times I was told this is what they have. Now, if a citizen can't get the original set of plans after 3 visits to community development, he should have a right to appeal.
Okay.
If I could mention the fact that the board seemed interested in the fact that July was some kind of time of construction. This is exactly when my letters started getting written.
Okay.
And as Mr. Ryan somewhat verified, if a letter isn't answered, it's deemed a decision. And so I had 30 days from that time. What I did was I wrote a second letter, and I submitted that affidavit with it.
I did not say that the failure to answer a letter is a decision, in all fairness to what I was saying.
Excuse me.
I mean, I'm trying to be,
Yeah.
I just didn't, I honestly, if
Okay.
I sounded like I was saying that, I did not mean to say that.
I don't know, there might be further comment, but I'd like to respond a tiny bit. The Community Development Department responded that this is a purely zoning matter. However, the sidewalk requirements, to repeat, are a good half or more of them are in the overlay, not the saldo, the amendments to Chapter 280. Thank you.
Okay.
And I'd like to ask to please present closing if no one else has anything to say.
With all due respect, we have heard your argument, and I'm not sure there's a need for closing. I think we've got it covered.
No, are there any more witnesses or
No.
participants?
No.
If I could have 5 minutes of your time.
Mr. Schneller, we've heard the argument. We understand the issues before the board, and I think we're ready to close the record and make a decision.
I'm sorry, but there's more fact I have to present. The master plan calls for,
Testimony
Yeah.
by Mr. Schneller. Enough is enough.
Sustain.
I don't know, could I please ask clarification of the meeting enough?
Mr.
Enough.
Schneller, the factual
You've
record's closed.
You've had 2 hours, Mr. Schneller, and you've taken up a lot of people's time here tonight. You've had your opportunity. And this board still hasn't ruled on your standing to go any further. So that's, I think.
Witness is attempting to advise the board, and you've elaborated on a number of factual issues. Did you swear tonight?
Mr. Rice is counsel to the township. He hasn't testified, and we haven't taken his
The board has
statements.
taken his words at full value, and some of it has been fact, and he did not swear. Just
As a-
keeping the record straight.
Mr. Schneller, as an officer of the court, I have an obligation under the rules of professional conduct in this state to be truthful. I've been truthful, and you've taken up enough time of this board, and that's the truth. So I would object to any more testimony,
All right, well, I have here.
and I have nothing else to add.
I have a schedule, and I'm on page 8, and I'm at the bottom half of the last page.
Mr. Schneller, we have had the benefit of all the testimony that you've elicited, all the testimony that you've given, and all the argument that you've given. So I think we've heard enough, and then we're going to close the record and vote on your application as it relates to standing.
Thank you, and I remain objecting to the, anything on the merits that went beyond what was necessary.
Noted. Thank you.
So, Mr. Chairman, we're closing the record. We're going to vote on the standing issue only.
That's correct, as to standing only. It is my view, in light of the testimony that's been given with respect to Mr. Schneller's standing, that he does not have standing as it relates to this matter. His property and his use and enjoyment of that property, in my view, in light of the testimony that's been given, is not adversely impacted by the construction at 103 North Wayne Avenue. Assuming, without deciding, that Mr. Schneller has standing because of Section 280-157B that discusses the ability of a person who shows that that his person was substantially affected by the alleged violation. I've heard nothing this evening that would support a claim that Mr. Schneller was personally substantially adversely affected by the construction at 103 North Wayne Avenue either. So even assuming, again, without deciding that that would be enough to confer standing, which I don't believe it does, I don't think he's got standing on that ground either. Kathy?
I agree, and I'd also note that he commented that the width of the sidewalk was a problem, but that seems to be one of the wider areas. What is the new construction seems to be a wider sidewalk than the adjoining properties. So I don't think you can use that reasoning that he is affected by the width of the sidewalk being narrowed.
Okay. Charlie?
I agree. I don't believe that he has standing in this issue at all. He's too far, and his property and his space within the township is not impacted by this area at all.
Okay. Peter?
I agree. I don't think there's standing. I don't understand where the appeal should go, but I don't think it's here in any case. But I don't think there's standing.
Okay. Cora?
I concur with Jim's analysis, and
Okay.
I believe that there is no standing.
Mr. Chairman, so the record is clear. We have ruled on standing and therefore will not reach the issues of timeliness or jurisdiction.
Correct. Mr. Schnell, your appeal is denied. Thank you.
Was it?
We just did. And you'll get an order. We're going to take a 5-minute break. Thank you for your patience. Thanks for your patience, man. Nice to meet you.
Can we start with that one?
The next matter on appeal is appeal number 2823. The applicant, Len Wayne Properties LP, property located at 417 East Lancaster Avenue, Wayne, PA, seeks to add additional parking for its 54-unit condominium known as Pembroke North Condominium. Applicant intends to provide 2 parking spaces for each unit, in addition to 16 spaces for visitor parking. Applicant's property is a split-zone district, being R6, R5. Applicant seeks a special exception and/or variance from Section 280-105F to permit parking within the front yard setback. Applicant further contends that it complies with Section 280-35B of the Code and 280-36.3A of the Code regarding impervious coverage, or, in the alternative, requests of variance. Continued from the November meeting. Mr. Cornelia. Good evening.
Matter. By way of brief introduction, brief opening, and the bottom 2 photographs, or the bottom 2 photographs, and the one here depict the current property. And the proposal is to raise this property directly behind this fence is the Pembroke North Condominium. They own this site. There's 54 units here. When the approval was given for Pembroke condominiums, the requirement is 2 parking spaces for each unit, which comes to 108 parking spaces, which is exactly the number that they have on the site, 108. The problem, of course, it leaves nothing for guest parking. So the proposal here is to construct this parking area, to raise this particular building, to construct the parking area that you'll see here, landscaped along Lancaster Avenue, taking away the ingress and egress from Lancaster Avenue. And the only way to enter the parking area would be for the Pembroke North condominiums back here. The only thing that we would have would be a sidewalk that goes from the condominiums out to Lancaster Avenue. And as I mentioned, there would be heavy buffering and landscaping both in the front along Lancaster Avenue and along the side. The facade of the, it would now be a single unit, would be consistent with the facade of the Pembroke North condominium. You may recall last meeting.
Excuse me, can you help identify, it's very hard to see what you're pointing to
Yeah, I
on the
know,
screen.
there's not. There are exhibits A4, A6, and A7 in your packet. A4 is the proposal, which is you're standing on Lancaster Avenue and looking at the site. A7 and A6 depicts the current structure that's on the site. You can't really see it, I know, because it's far away, but would you be looking at A4, A6, and A7? And I'll go over it too during the presentation. It may make it a little bit easier.
And what's the view of A4?
A4 is a proposal from Lancaster Avenue. So you're looking at the site from Lancaster Avenue as to what the proposal would be and what the site would look like.
And the large structure in the foreground is one of the buildings that,
That's the Pembroke North Condominium. And the one up here is the dental office there.
That's what I mean.
Yeah, that's Ken Fetter, who's here. That's his dental office. And Dallas Pulliam. Just by way, again, you may recall last hearing, we continued it. One of the adjoining property owners to the right of the site here, Jim Levin was present. He owns the Crestwood Apartments along with his brother. And we had discussions with them, and we've entered into an agreement in that regards as to if this request was granted, as to conditions that we would agree to if the request was granted. And there's a number, I believe there's 16 conditions that would be agreed to between the applicant and the adjacent property owner. And I know Mr. Levin would just, would like to say also, if these conditions were not incorporated, that he would still reserve his right to oppose the application.
Excuse me, if you'll raise your right hand, I'll swear you in. Who comes to tell the truth, the whole truth, nothing but the truth?
I do.
And state your name for the record.
My name is James Levin, Levin. I previously entered my appearance at the last hearing, but I have another copy of that, a written one for the records. I don't know.
Okay, thank you.
As Mr. Cornelia said, we entered into an agreement, should you do it. We have a list of conditions. However, I composed a statement in opposition to reserve my right, reserve our objections in the event it's approved differently. And I'd like to submit those to you, if I can move to have that admitted into evidence.
I guess it's sort of a conditional opposition. If we oppose,
Conditional opposition.
So why don't we hold it to the end, see how it goes?
I think in all fairness, if we vote with, if we close the record and then vote without the conditions,
Then I don't
it
have
wouldn't
mine.
be in the record. I think I think if he's allowed to put it into the record and it's and you've testified that this doesn't apply if we grant the approval
With
with
all
all
the
the
conditions,
conditions.
Or theoretically, well, I guess he couldn't withdraw it after we vote, right, because the record
No,
would be
records,
closed.
I mean,
Okay.
Well, after you
that's fine.
vote, it's
Moot.
a done
Right.
deal. And
Well, as long as it's put in with the understanding that he's only I mean, basically, you're testifying that if this, you and your client support this, if subject to the conditions only, and otherwise you do not support it.
That is correct.
Okay.
And we're amenable to the conditions, they were negotiated between.
They've been accepted by the applicant.
I've marked as A12 those conditions, and I'll
Okay.
hand copies of those up to the board.
Yeah, I think, how many copies do you have? Okay, I could have one, and then, I think we need to put these, put some exhibit numbers on this. Is this gonna, I guess this would be P1. Well, P1 would be, actually, I would suggest that P1 is Mr. Levin's entry of appearance. And P2 would be the statement of opposition, which is conditional. And here's more copies of the statement of opposition. I guess they should be labeled P2 as well. I forgot to do that. Okay. A12 is the conditions.
Yes, A12 is the conditions. I can, do you want me to call the first witness, or do you want to review the conditions first?
I have a problem with two of them. I have no problem with them being recorded as a deed restriction in toto, because the question is whether they're valid as a title matter. But two of them jump out at me as being beyond the scope of this board. First of all, will not take to have any action to have the premises rezoned to a different zoning district. That's not something that you can
But
say
we-
that.
We will agree to that.
Well,
not
that
to
would be
do that.
something you could do, but I don't think we can put that in an approval, because frankly, I don't think the board has authority to
But if we're-
waive the right of
That-
a person to approach the sovereign.
But that's an enforcement question.
Right. We're agreeing to it, and then we're going to record it as a deed restriction anyway.
Right.
So since we're agreeing to it, I
It's not
think the
something
board
you're
can put it in. If it
Well,
was something that.
It
that-
would be theoretically unenforceable.
Well, I don't think we should put something into an approval that's clearly unenforceable from a zoning perspective.
But
That's
if
the
we're agreeing
point.
to it, then we're bound by it,
Okay.
right? If we're agreeing to it, we're bound by it. It'd be different if we weren't agreeing to it, then obviously we can contest the condition. But since the applicant's agreeing to it,
And you
at
have
this
the
hearing.
benefit of the deed restriction as well.
Right.
If you put it in as a deed restriction, again, if the board wishes, it could be approved, but I don't think that's enforceable. I also don't think that number 8 is enforceable. That's policing registration of cars and so forth.
But
I don't see how
if
that's.
the protestants, if the protestant understands that, then that's up to
I understand it's
the.
not enforceable by the zoning hearing board, however, those are the conditions that we wanted to agree to in order to move this thing along, and so that everything is consistent and going forward in the
Yeah.
deed restriction.
As long as, we understand, that you can agree with what you want, you can put of record what you want, which is your last condition. Whether it's enforceable of record in itself is, a private restriction. Zoning boards don't.
If it's granted, what we're going to do anyway is we're going to record this before the appeal period expires, so.
So that's my enforcement.
Right. I don't have any trouble with that. Okay. Nick, floor is yours.
Ready to go? George?
Oh, I see.
I do. George Hall, H-A-L-L.
George, if you want to.
Want to go over there?
George, what is your relationship to Len Wayne Properties LP?
I'm the Senior Vice President for Len Wayne Properties.
And what is your particular position there? I mean, what do you do?
Most of my responsibilities fall within the sales and marketing aspect of the project, as well as complete budgetary responsibilities.
Like, how long have you been involved in sales and marketing of real estate?
I've worked for Jerry Lenfest for over 20 years.
Okay. I'm going to show you what's been marked as A2, and that's a deed to the property indicating Len Wayne Properties LP is the owner, having purchased it from Frank and Carol Cassidy.
Mm-hmm.
And you purchased that in 2006, correct?
That's
May
correct.
2006. And prior to 2006, how was the premises used?
As a residence.
Okay, for Carol and
Frank.
And Frank. And after 2006, after you acquired, how has it been used?
Well, it was really used as a means to access the project site. Really nothing more.
Okay.
A staging area, coordinating, and project access.
Yeah, and in fact, talking about the Cassidys, and I haven't marked this, and I can mark it as an exhibit. I'm just going to mark as A13. I mentioned in the application that the Cassidys had actually gotten zoning approval from this board under appeal number 1981 to convert this site to office use, and which is similar to the adjacent, or the other twin, the twin on the other side, the dentist's office, which also was granted relief for office use. And I'll just hand it out to Mr. White. I marked it as A13. Now, up and down Lancaster Avenue, say from Stratford to Villanova, are there many single-family residences?
Not that I'm aware of,
Maybe one or two tops?
I would say.
Currently, the house is vacant,
It is.
and how long has it been vacant for?
Oh, for quite some time. It's been vacant. Really, it has not been utilized. The interior really hasn't been utilized since we purchased it.
I'm going to show you what's been marked as A3. And this is a zoning plan prepared by where's it? There's Dave Brandt's seal on that. And just the rear of this is where the condominiums are located, correct?
Yes.
The 54-unit condominium, and this is the Cassidy property that we've been referring to here.
Yes.
And you have 3 buildings back here, correct?
That's correct.
And how many units are there?
There are 54 total.
And how many parking spaces do you currently have on this site?
Well, we have 92 parking spaces in our garage, and we have 16 visitor parking spaces total, for a total of 108.
Okay, why do you need 2 per unit? Actually, you have 108, which conforms to zoning, right? 2 per dwelling unit?
Right.
What's the need for 2 per unit?
Well, as I'm sure the commission members are aware, we are dealing with some very difficult economic circumstances, and not having additional parking has become a bit of an issue with our prospective buyers, quite frankly. Concern for overflow from our prospective buyers is significant, especially when you're competing against other developments who have, in some cases, almost unlimited parking. We have, as I'm sure you folks are aware, we are a LEED certified project now, which is Leadership in Energy and Environmental Design, and part of that designation was to be close to the train station, hoping that people buying into our project would, if not abandon their cars, limit their use. And to a certain extent they have, but there's a reluctance for people to give up both of their automobiles entirely. So what we've really found is that by possibly utilizing this property, 417 East Lancaster Avenue, as additional parking for our residents, we're able to compete a little better, quite frankly.
Okay, you mentioned 417 East Lancaster would be used as parking for the residents. Is that, so it'd be strictly for parking for the residential, for the people who live at this site?
That is correct. All of the parking out front that was designated visitor parking will remain visitor parking. That's 417 East Lancaster Avenue will exclusively be for residents.
May I ask you a question?
Yes, ma'am.
The application states that you need the additional spaces for visitor parking, but your agreement with your neighbor specifically states that it's not to be used for visitors. So where are you picking up the additional parking for visitors?
The visitor parking will actually be designated in front of each of the buildings. 417 East Lancaster Avenue will be exclusively for residents.
Were those spaces counted in for resident parking before? Or
Well,
were they visitor parking?
They were included in the initial 108 spaces, yes, ma'am.
Okay, so the ones out front were assigned to residents before, and now they're going to be freed up for visitors? Is that the way it works?
Well, they were not assigned for residents out front. They were clearly marked for visitor parking. The issue becomes the additional parking required for each of the units.
The code, yeah, see, the code requires 108 spaces, doesn't say how you're going to use the 108 spaces. The initial intention was to use 92 spaces for the 54 units, and then you would have 16 spaces for visitors. Now, what they found out in the marketing is that everyone still wants 2 parking spaces, even though they may not be driving as much since they're living at this site. So the proposal would be to keep the 16 visitor spaces up top here, and then use the 16 spaces in this area for residents. And the part of the theory behind that, too, is that these cars would not be moving much because they are being used for the residents, and they'll probably be used for their additional car because they're going to want to have their main car probably located underneath their apartment, you know, or their condo where it is located now. So the idea would be that these cars probably would be cars that would be parked and be a second car for these people, and then, of course, you would use, the visitors would still park in front of the units themselves, in front of the buildings themselves.
I have a couple of questions. You probably know what my questions are.
I know.
I'm a little confused as to the impervious coverage.
Right.
You have here that you're combining the two, which kind of isn't really, in my estimation, fair, since you have that little piece at the very top that belongs to 6, and the other 99% belongs to 5, R5. So I'm kind of looking at you're really covering the entire parcel, just about, because you're going from 64% impervious, okay, that's there now, up to 78.7% impervious. And in the zoning, it really requires 36%. So I think that, for me, I think you really kill two birds with one stone. If you can get back to the 64%, right, I think you'll slide enough back in that you'll be inside the front yard setback. And I don't know how many spaces you'll lose. Maybe you can tell me.
Yeah, 4.
4. So, okay, so you're gonna have, instead of 18, you're gonna have 14?
Yeah.
It was 16 to 12, I believe.
Okay.
Yeah, 16 to
be down
12.
to 12. I think, and that will make it a whole lot better along Lancaster Avenue, because then you have more green, and then you don't even need to be here.
Karen, why don't you explain how we arrived at those numbers, and particularly the blended numbers? And
Yeah,
remember, this is all owned by the same
I understand,
entity,
but
and
I
that's
mean,
why
I
we
don't-
blended them.
I'm having a hard time that you have that the little piece up top really belongs to 6. I mean, you're blending such a small piece into the whole, into the ultimate parcel. I mean,
No, we're blending, what we were blending is the whole thing.
That's what I'm saying.
Yeah,
You're blending, but you're using the R6 as the reason why you're blending it.
Could I just ask a couple of questions? As I look at this plan, the northern border, I guess it is, of this parcel as it stands now is at the R5 residential district, and you're just sort of adding a little tail end from the other. Is this all going to be consolidated into one lot?
Yeah, it's going to have to be consolidated into one lot if this is approved.
Yeah, because otherwise
Right.
you're having parking as a principal
Right.
use.
Yes, right.
The deed restriction only applies, though, to the premises, so it'll be like an easement or covenant area over the property.
Yeah, we'll have to merge it anyway, you're absolutely right. And that would be a condition that we would accept if you were to approve it, that we would have to go to the Board of Commissioners at some point
this
to merge the
clearly
two
would have to
lots.
be. The
Yeah,
other
because,
thing-
you know, basically, as we said, they're the same common owner. They were acquired at different times, and we would have to remove that property line and merge it so that, and see, that's part of it, part of Mr. Falcone's question too, because these are going to be merged, and what you really have is one lot divided by the R5, R6 zoning line. And that's where we came up with the blended formula, and I'll have Karen, who's the engineer on the project, explain how she
I'm
arrived
not
at that.
sure in the
I'm-
zoning code that you get, I mean, I don't know where blending comes in.
No, I
Zoning
mean,
code.
I know how the blending goes. What you're really doing is you're covering the entire lot. I mean, the bottom line is you're covering the whole lot that you're buying. And you're going from what was originally there, 64%, and you're gonna push it all the way up to 78.7%. I'm gonna have a hard time with that one,
The other point.
especially since I spent the last 2 days pumping out my basement.
Uh-oh. The other thing is that the special exception in the front yard, I believe, only applies to
You can't have a
commercial.
special exception, it has to be a variance.
Yeah, because
105 doesn't let, it's only in the
Commercial and office.
Commercial office district.
so I think the special exception isn't available.
It's not
So I think this is a
non-option.
variance case on impervious and
Yeah.
on.
Although if you notice in R5, they give you two front yard setbacks. One's a 25-foot setback and one's a 50-foot setback. That's why we have both of them in there. We really weren't certain which one was applicable either, and so I figured obviously I'd ask for the relief just in case we did need it.
I think if you get to 64%, I think all your problems are solved.
But let me swear in Karen anyway and
Okay,
get her,
yep.
their testimony on the record.
Again, if you'll raise your right hand, you swear to tell the truth, whole truth, nothing but the truth.
I do.
And state your full name, please.
It's Karen McManuels, McManuels,
And Karen, what's your profession?
civil engineer.
And you're a registered civil engineer in the state of Pennsylvania?
Yes,
And you were involved in this project?
yes.
Okay, and what's the name of your company?
Associated,
I can't hear you.
I'm sorry, what's the name of your company?
Associated Engineering Consultants.
Okay, and could you explain to the board how we arrived at these numbers regarding the impervious coverage in particular?
What we did is we took the two individual premises here, the R6 zoning, and ran the calculations just on that piece, and then the R5 the Cassidy property, which we're developing, and did the percentages on that. And what we did is to blend them, we proportioned them out, and below the schedule down here, we show you how we proportion them out. In particular, the total impervious coverage, taking the total square footage times the allowable 70%, plus the total square footage in the R5 times its allowable 36%, and then divided it by the total square footage to come up with the total 67.5 percent of total impervious.
Have you figured it out, what the percentage of impervious would be if you were to move the front yard back to the 50-foot mark?
To the 50-foot mark? No, I did not.
I've looked at it actually this evening as I was sitting there during the first hearing. And I believe we would still be approximately 200 feet over the existing. We would be at, if we moved back 50, we would lose 3, and we'd be approximately 223 feet.
Over impervious?
The existing.
What percentage?
The existing impervious as it exists.
On that
On
particular
that
lot? Or
parcel,
the-
just on the R5
Okay.
lot.
Matt, what is the required size of a parking space?
It's in 255, it's 9.5 by 20.
Okay. Have you considered going to a slightly smaller parking spot if the cars aren't moved that much?
We did not look at anything smaller than the standard parking space. I mean, if we were allowed to make them smaller, we would do that.
And you would be able to move away from Lancaster Avenue as a
Well,
consequence.
We would pull it away from Lancaster Avenue, although we would still lose parking spaces, because I wouldn't gain enough. Assuming I could take it down to 9 feet versus the 9.5 feet, I'm only going to gain 4 feet in each space, so I would only gain.
130 feet.
Right.
Is what you would gain.
I
It's
would get- I
130
would-
feet, so 130 divided by 9 is what you would get.
Right, I would gain 8 feet, but I would end up losing 3 spaces, so I'd still lose a net 2 spaces, even if I shorten up the
14.
spaces.
Would that address the impervious, how would that address the impervious coverage?
I don't know if that would get us down to the 64%. I'd have to run that
Yeah,
calculation.
we'd be over by 223
What-
square feet.
What about the front yard? How does that improve your front yard situation?
That would, if we
If you
took it back, we
Yeah.
would, actually, if we took it back, we would comply with the front yard setback. We would get, as I said, 12 spaces in, and we'd still be a little over 200.
I thought you said 200 for 3 spaces, Nick.
That was 223 feet. If we moved it back to the front yard set, I'm sorry, yes, it's 3 spaces. So we would pick up
You could probably
approximately
pick up
3.5
another space or two if you went to 9.
3.5
Well, if we went to
by-
9 foot, we could pick up 1 space, but if we pushed it back to 50 feet, we're losing 3. We're losing 3, picking up 1, so we're still losing 2 spaces as a net, putting it back.
It's only 3?
If we pull it back to the 3, it's 3 spaces that we lose, 1, 2, 3.
If we went 9-foot wide spaces, we would lose 2 by pulling it back to the front yard setback. And we were approximately 130 feet over on the impervious instead of 223. Because we pick up a couple feet there.
And if you bring it back to 64%, how many spaces do you lose?
Like if you lost
We
the
would
3
probably
there.
lose the 3.
We would lose 4 if we had 9.5 by 20s.
And if you dropped it to 9 and you'd have how many?
We
you pick
would
up a
lose
space?
3. So we would have 13 instead of 16.
And if I may, folks, one of the reasons that we really feel the need, especially for the visitor parking. We only have 7 families living in our first building right now, just 7. And there are many days when all of the visitor spaces in front of that building are currently filled. Visitors cannot access our garage, obviously, so the people that are taking up those spaces currently are true visitors. By losing spaces at 417 East Lancaster Avenue and not having 2 spaces per condominium, even if we were to dedicate several of the spaces out front, the current visitor spaces, to buyers, I think what we will experience is the same sort of hardship we're experiencing now. It's very interesting to watch this occur. 7 units out of 18 in building 300 are sold and settled, and on many days those visitor spaces are already filled. So if that gives you a sense of our predicament.
But again, I go back to the question, you can't use that new space for visitors. So how is that going to change?
Well, ma'am, what will happen is, again, as we sell units in building 300, additional units, those spaces at 417 East Lancaster Avenue will be dedicated to specific units.
But you just said that your visitors don't have access to the garage.
No, our visitors do not. But what I'm saying is, all of these additional spaces will be freed up for visitors instead of just owners. There are owners at times who pull up, who don't necessarily want to park in the garage, who pull up for a few minutes. They would be able to access the spaces at 417 East Lancaster Avenue versus sitting in those visitors' parking spaces. It's just a very interesting phenomenon to watch those spaces fill up.
What's the likelihood of an owner in Building 100 wanting to park at 417 for a few minutes?
No, sir. Building 100 parking spaces, what this will allow us to do is to dedicate all of the spaces underneath Building 100 and Building 200 to residents to those particular units. These spaces will be used exclusively for secondary parking for residents of Building 300. So the proximity is right there.
How many spaces do you have in the front?
In front right now?
Right.
16.
16.
Yes, ma'am.
But if
And
you're
how
saying-
many of them are dedicated to visitors?
All of them.
So we don't have 2 dedicated per unit.
Okay.
We have 92 dedicated spots currently for 54 units. So there are, as you can, if you do the math, there are quite a few units that only have 1 parking space.
Now, Karen, is there any place to put additional parking on the upper portion of the site?
No. We had
I don't
maxed
understand
that out.
how your 16 visitor spots are going to be more open to owners, even if you had what you're asking for, compared to today.
No, that's not my contention.
I understand that they'd be available, I just don't understand how they'd be, why they'd be used.
Well, no, what I'm simply saying is the owners in what's happening currently is several of the owners will park out in front of Building 300 for a period of time. They'll park in the visitor spaces. They're not there very long, but they do fill up those spaces. If we were granted the variance to use 417 East Lancaster Avenue, that space would become available for the owners to utilize, and all the spaces out front would be exclusively visitor spaces.
I remember almost when you came in and asked to do this, I thought we talked about parking and that we thought you needed more parking, and Kathy can maybe remember some of this. It wasn't an issue. If I remember correctly, you said, oh, no, we're okay with parking. Now you're having a problem with parking. I'm telling you, I'm having a hard time with the impervious. You're going to have to figure out how to solve that problem. You know, I mean, I'm okay with the little smaller lots, you know, for parking. I mean, I can give you that one. I just, you know, we just too much water. I mean, every time someone builds and fills something, somebody's basement's flooding somewhere. And it's, you know, it's a real problem in this township. I mean, this township has a water problem.
Yeah, one thing I will point out here, and I'll ask Karen the question. Karen, currently, is there any stormwater management at all on the subject site, the 417 East Lancaster site?
No, currently there's no stormwater management, and as part of this development, we are proposing to maintain and manage this water. We have an underground, and we do have an infiltration of the 2-year, and we are managing the stormwater before it comes off site. So it'll be less discharge coming off that site than there is right now.
May I take a
Yes.
quick recess for a couple minutes?
Sure.
He's telling you. Well, it's also.
I mean, this is an opposition party. How can it be part of it?
But there's another thing. That's unenforceable.
Yeah.
Okay. This is unpoliceable. Okay. Like, here, this one. Are we going to issue a citation because somebody allegedly parked a car who was a guest or something like
But
that?
again, this is not applying to us. It is
Well,
applying to the developer.
my suggestion to
Yeah.
Jim, and I'll make it public, is that if
Okay.
they want this, this is a private document. The township should not be
Get
involved,
involved.
particularly since it's awful that it's basically having the township be potentially a free policeman for
Yeah.
Crestwood. Okay, that's not what we ought to be doing. What they ought to do is write this document up
Why don't,
and make it conditioned upon getting the approval
Yes.
and then getting it recorded. Okay,
Yes.
and then have Crestwood enforce this. This should not be. Mr. Cornelia?
Yeah, we would respectfully ask the board to grant us a continuance to next month on this matter. We'll try to come back with a revised plan.
No. No. I think, please, and your mic's not on, John.
I've been looking at these agreements. They're perfectly appropriate private agreements, but a lot of them, a couple of them would clearly not be enforceable as part of a permit, and others, which arguably might be, it seemed to me, really run to the benefit of Crestwood. And the township, particularly with its, strained resources now, should not be put in a position of having to enforce what amounts to private restrictions for anybody. Sort of become a voluntary free policeman, and I'm not denigrating the restrictions, but it seems to me the appropriate place for all of these restrictions would be in a private document which could be made conditional upon getting the final unappealable approval, and not have it part of the permit.
I'll speak to Mr. Levin about that.
That's my recommendation to the board. I don't think that this belongs, I'm not denigrating the substance in terms of are they good ideas or bad ideas, but I do think these are private restrictions that are really outside of the scope of a permit.
Okay.
One other comment. To the extent you guys have not already done so, I'd recommend that you meet with the neighbors.
Who is here? Cheryl? Okay. I mean, Cheryl, I know lives.
I know you always question whether I have standing.
And if you stood up, I would, well, I don't know, Cheryl. I still would object to your standing, but I'll talk to you about it. Okay. The Wella Court? I mean, I'll contact Cheryl. I'll contact Cheryl.
Mr. Cornelia, I will leave it to your, Mr. Cornelia, I'll leave it to your
contact
discretion
Cheryl and,
as
I'll
to
let
the
her
appropriate
decide
folks to
who
meet
wants
with.
To be there.
Okay. Anybody have an objection to the continuance?
The only thing I say is that continuance on the supposition that you do in fact meet with the neighbors. Okay? You need to meet with them.
And work on the impervious.
Right.
Thank you for your time.
Thank you. We're adjourned. Thank you, ladies and gentlemen.